Hi, this is Chuck Roulette with the Roulette Law Firm. I'd like to welcome you here. We've put together this presentation on the Secure Act for our clients and friends of the firm. And we've done this to walk through what the Secure Act has done, how that may impact you, your family, particularly on any planning you may have already done for your IRAs and 401ks, whether that was by beneficiary designations you have in place, or if you worked with us to put together a standalone retirement protection trust. So we're going to walk through what the Secure Act has done, how that may impact your planning, and then we're also going to show you some planning techniques and strategies that you may want to consider now going forward based on this new law. Now, as you may know, we have been tracking this law since it was first suggested or first came to possible fruition in the House. The bill originated in the House of Representatives, quickly passed the House, and then was sent over to the Senate. And at least initially, it looked like it was going to get hung up in the Senate and not pass. And then in the 11th hour, the Secure Act was appended to the appropriations bill, cleared the Senate, and then the president signed it, and it went into effect on January 1st of 2020. Now, as you can imagine, anytime a law of this size and scope is enacted, the IRS, the Internal Revenue Service, also goes through the law and then issues guidelines and how it is going to choose to interpret key provisions of that law. So since its passage, I and my colleagues and other experts around the country have also been going through the law to see what it did. We have been sifting through and reviewing the IRS's guidelines and its interpretations. And so now, based on that, moving forward, we're going to again give you some planning strategies and tactics that you may want to consider to both minimize taxes as well as to protect your qualified retirement accounts. So with that, let's jump into what's been done here. Now, the Secure Act, we're going to talk about what it is. And it's an acronym. So again, Washington loves its acronyms. So the Secure Act stands for Setting Every Community Up for Retirement Enhancement. So that was their official acronym. And as you are probably aware, Washington loves its acronyms and loves to use them as sort of doublespeak. And so as you are going to see here in the presentation, we prefer to refer to the Secure Act as setting every community up for reduced enjoyment of retirement. And you're going to see that, I think, as we go through what's been done. Another acronym we like to use for the Secure Act is some extremely complicated and unusual rules enacted. And again, you're going to see that as we walk through here. So to, again, understand the Secure Act, you're going to see that with its passage, there's new, heavier taxes, and it impacts not just IRAs, but employer retirement plans that may be rolled into IRAs. We're also going to show you why your existing IRA planning may need to be updated and what you can do about it. So again, to understand the Secure Act, we have to talk first about what the rules were surrounding IRAs, 401ks that may be rolled into IRAs prior to passage of the Secure Act. So we're going to walk through what the old rules were. So under the old rules, the game plan was to delay withdrawals for as long as possible. And in doing so, minimize income taxes and increase the wealth that was passed on to future generations. And that was usually done by deferring your initial withdrawals until 70 and a half, taking only required minimum distributions during your lifetime, and then upon your passing, naming beneficiaries in a way that they could maximize the stretch out of their required minimum distributions over their lifetimes. So as you probably know, prior to passage of the Secure Act, when you put money into an IRA, it was pre-tax. That money was then allowed to grow tax deferred. At 59 and a half, you could start withdrawing funds from your IRA without penalty. Once you reached 70 and a half, you had to start withdrawing distributions from your IRA. It was called the required minimum distributions. So once you reached 70 and a half, the IRS had published a life expectancy table. And so each year after you'd reach the age of 70 and a half, you'd look at that life expectancy table, and you would go down the chart, you would look at your age, and you'd go across and it would show you a number. That number then was divided into the principal amount of your IRA, and that then showed you how much you had to take out of your IRA that year and pay taxes on. Again, it was known as the required minimum distribution. So if you were to pass and you had a balance in your IRA, and let's say you named an adult child as the beneficiary, that child then became the measuring life for required minimum distributions. So again, that, let's say your son or daughter was maybe 45 at the time, or 50 that they inherited that IRA from you. So then they would look at the life expectancy table, they'd take their age, they'd look at that number, they divide it into that IRA, and that was how much they had to take out that year. Well, because they were younger, the amount they had to take out was less, and the principal continued to grow tax deferred. That was what was known as the stretch. So show you an example of the power of the lifetime stretch out. So let's assume when you passed away, just for this example, that you had a $200,000 IRA that you passed along to your son or daughter. And the math on this, when we taught it, is that kind of the rule of thumb is that an IRA properly stretched was worth about 4 to 5 times the face amount. So again, if you took a 40 or 45 or 50-year-old beneficiary and they had that $200,000 IRA invested, and let's say it averaged an 8% return over the lifetime of that investment, which is not outside of the realm of possibility. The stock market averages about 10% overall. So let's just assume that it was averaging 8% over their lifetime, and they were just taking out the required minimum distributions each year. If they did that, that IRA could be worth somewhere between $750,000 to about $1 million over the course of their lifetime. Again, that was what's known as the stretch out. But this assumed they actually stretched that IRA. What we were finding, and this is backed up by studies out there, as well as talking anecdotally to my colleagues across the country, financial advisors, most adult children, most people, when they inherited an IRA, they tended to cash it out. They would just go in, saw it as a pot of money to pay the bills or whatever, and they cashed it out. They paid the taxes and just cashed it out. And part of that was because no one had explained to them the ability to take the RMDs and allow the principal to grow tax deferred. Occasionally, we saw people do what was called a blowout, where maybe this had been explained to them. They intended to do the stretch out and allow this to grow tax deferred, but they made a mistake in how they handled it. So for example, maybe they were going to take that IRA account and roll it over into their own. Well, in order to do that, it had to be a custodian to custodian rollover. So in other words, the custodian of the IRA had to cut the check directly to the custodian of their IRA. If they cut the check directly to your son or daughter, that was known as a blowout. They've blown the stretch. So we were finding a very large percentage of people were not actually doing the stretch out. And then even those that intended to were often making mistakes in doing it and were losing the advantages of it. Even if they chose to take the stretch out, prior to 2014, so let's say they opted to do the stretch. Prior to 2014, inherited IRAs were deemed to be creditor protected. That meant if an individual got sued, got divorced, maybe had something arise in their life, that inherited IRA was creditor protected. Well, that changed in 2014 in a famous case called Clark v. Ramaker. And it was a case that originated out of the state of Wisconsin. So a woman passed away. Her daughter inherited her IRA, did the smart thing and took the stretch. And at the time, that IRA was worth about $300,000. So she took the stretch on it. So each year she was looking at the life expectancy table, figuring out how much she had to take out, taking that amount out, paying the taxes, allowing the principal to grow tax deferred. And then about 3 years later, she and her husband ran into some financial difficulties and filed for bankruptcy protection. And only the second time in history that any of us can find in any of the cases, the federal bankruptcy court allowed the creditors to take the inherited IRA. So, sort of a game changer. And at the same time, an almost identical fact scenario occurred in another federal bankruptcy court where the bankruptcy court held with sort of the old rule that inherited IRAs were creditor protected. So we now had a split in the federal bankruptcy courts, which meant that the case fast-tracked to the United States Supreme Court. So again, we've got one federal bankruptcy court saying that these inherited IRAs are protected in bankruptcy, and another federal bankruptcy court saying they are not, the creditors can attach them. So case goes to the U.S. Supreme Court. The U.S. Supreme Court looked at everything and said, well, because you didn't actually contribute to this IRA, and because you can take it out at any point without penalty, in fact, you are required to, sort of take the RMDs and things, despite the fact that this is considered a qualified retirement account. This looks a lot more like cash in the bank to us, the court, than it does your individual retirement account. They allowed the creditors to get it. Game changer. So again, prior to Clark v. Ramaker, an inherited IRA was creditor protected. Now the U.S. Supreme Court said it isn't. So prior to Clark v. Ramaker, there was a sort of category of trusts. We refer to them as retirement protection trusts. And we were using them for beneficiaries that we knew had issues. Okay, maybe it was substance abuse. We knew there was poor money management skills. Maybe they were receiving government benefits. And these trusts were designed very specifically to meet the IRS's requirements for getting the full stretch. Now, sometimes a client would ask, well, if I'd set up a normal revocable living trust, why would I not just run my retirement accounts through those? Well, there's language that we have to have in a revocable living trust that can run afoul of some of the IRS requirements in order for us to get the full stretch. So what we were often doing was naming the adult children as the beneficiaries. They could stretch or not if they wanted to, but it was at least creditor protected. But we were still using these trusts when we had beneficiaries that we knew were not going to do the stretch. Again, maybe it was a substance abuse issue. Maybe we knew they had, poor money management skills, were receiving government benefits where if they got it, it was absolutely going to be lost. So we'd already had these retirement protection trusts in place. And then after Clark v. Ramaker, we started doing a lot more of this planning for our clients. And if you're watching this, you may have one of those trusts in place. So the trust was designed very specifically to meet the IRS requirements to both get the stretch on that IRA for the beneficiaries, while putting back into place the creditor protection we lost as a result of that decision, the Clark v. Ramaker case in 2014. Now, as you're going to see, passage of the Secure Act, this planning may no longer work. And just because of the way those trusts were designed, they may not be tax efficient. So this was the planning prior to passage of the Secure Act. It was lifetime stretch out on an inherited IRA for a beneficiary. If they elected to do that, an IRA that was properly stretched, kind of rule of thumb is it was worth about 4 to 5 times the face amount. creditor protection prior to 2014, the Clark v. Romiker decision, no creditor protection afterwards, and thus the use of standalone retirement protection trusts to both get the stretch on those assets, to stretch out the required minimum distributions as long as possible, defer the taxes, allow the principal to grow tax deferred while putting creditor protection on that inherited IRA. So those were the rules prior to passage of the Secure Act. So now we're going to walk through what the Secure Act has done, what the new rules are. Okay. So first, the new rules apply to IRAs that are inherited where the owner has passed after 2019. So 2020 going forward. Again, the law was effective as of January 1st, 2020. So it applies on IRAs from January 1st, 2020 moving forward. And as you're going to see, it requires much faster required minimum distributions for your heirs. That results in more taxes more quickly, and thus there are less for your beneficiaries to live on during their own retirement. In fact, as you're going to see, really what this was is a massive tax increase. Okay. So again, the new rules, much faster required minimum distributions for your heirs. It's going to result in more taxes more quickly, and there's going to be less for your beneficiaries to live on during their own retirement. This is what the new rules have done. So first thing to be aware of is prior to passage of the Secure Act, when your beneficiaries inherited an IRA, they could take the required minimum distributions out over their lifetime. After passage of the Secure Act, they now have to, for the most part, take the required minimum distributions out within just 10 years. So again, rather than taking RMDs over maybe a 30, 40, maybe even a 50-year period of time, for the most part, there's some exceptions and you'll see that, they now have to take those required minimum distributions out within just 10 years. Now again, a few exceptions. Surviving spouse. So if you name your spouse as the primary beneficiary of an IRA, they still get to take the RMDs out over their lifetime. If you have minor children, a disabled child, or somebody that is chronically ill, okay, and or someone not more than 10 years younger than you, with the exception of a minor child. These are what's sometimes referred to as eligible beneficiaries under the Secure Act. Okay, they still get the longer stretch. They can stretch it out over a longer period of time than 10 years. So for example, a minor child, they would take RMDs until they've reached the age of majority plus 10 years. So once they reach the age of majority, then it's 10 more years. Somebody who is disabled, it's a longer period of time. So these are what we sometimes refer to now under the Secure Act as eligible beneficiaries, and there's very complex rules around that. So they still get the longer stretch. However, for most beneficiaries, they are going to be subject to a 10-year. So again, that quicker payout means faster taxes, probably in higher tax brackets, and less tax-free compounding. Again, we're not getting a lifetime tax-deferred growth on the principal. So again, the rule of thumb prior to passage of the Secure Act, an inherited IRA worth about 4 to 5 times the face value. So as a result of the Secure Act, we ask the question, how much do your beneficiaries stand to lose now due to the 10-year rule? And the rule of thumb is approximately 45 to 55% of the inherited IRA is now going to be lost. So again, in the prior example of a $200,000 IRA eventually worth, say, ballpark $750,000 to $1 million to your children, well, thanks to passage of the Secure Act, approximately $375,000 to $500,000 or more is now going to be lost because of having to withdraw those funds much faster at higher tax brackets, resulting in higher taxes and less tax-free compounding. So again, the goal of proper planning now is to recoup some or all of the money that is now being lost to these taxes. So occasionally I'll have somebody ask, well, this, it doesn't affect me. I'm still, just taking the RMDs out based on my life expectancy. I pass, I can name my spouse. They still get to take the RMDs out over their life expectancy. So why does this matter? Well, do your beneficiaries have or will they have the same generous company retirement plans that you had or may have? Again, under the old rules, your IRA could largely grow tax-free until taken out by your loved ones in their later retirement years. They inherit that IRA, they're just taking the required minimum distributions out over their lifetime. It continues to grow tax-free. Well, that's no longer the case. And for many of my clients, they realized that their own children, were not having the same, contributions from employers. They maybe didn't no longer had defined benefit retirement plans. And so they were using this planning to help make up for reduced employer plans that their own kids had. And now, after passage of the Secure Act, this is really impacting that because the inherited IRAs are now going to be subject to much faster and higher tax treatments. Also, your loved ones may now face a much greater challenge ever retiring. College costs are increasing substantially. Many of my own clients, they're looking at their grandchildren, and the fact is college costs continue to rise at a much faster rate than inflation. And so your children are having to contribute a much higher percentage of their income to help their children, your grandchildren, get through college. And so that's money that is now having to go to college versus maybe your kids contributing to their own retirement accounts. Medical bills continue to increase much faster than the rate of inflation. So as many of you know, I teach advanced planning techniques all over the country. Teach through a number of state bars, have written a number of books on planning and are continuing to do so. And as I was doing research for an upcoming book, I was looking into the reasons for bankruptcy and study out of Harvard University. 65% of personal bankruptcies are unpaid medical bills. Now, that did not surprise me. But as we dig deeper into that study, we found out that 70% of people actually had medical insurance. And what happened is when they became ill, either their medical insurance didn't cover everything, or while they were out of work due to their illness, they fell behind on mortgage or rent payments, car payments, other things, had to put those things on credit cards, found out they just could not dig back out of it and had to file bankruptcy. So number one cause of bankruptcy in the US, unpaid medical bills. And the other thing that many people are discovering is now due to the pandemic that is going on as I am putting together this video, over 30 million Americans are out of work through no fault of their own. Many of them have lost their employer-provided medical insurance. And while there are possibilities of going on the exchanges and things, a lot of people are finding out that they are now without medical insurance. And again, very likely to see bankruptcy going forward, either due to job loss and or loss of medical insurance during an illness. Also, increased taxes. With the spending that is going on, and again, do not mean to get political here. I don't know what anyone's political viewpoints are as you are watching this, so I'm going to paint with a very broad brush. Because again, my intent is not to offend anyone, but both Washington at the federal level and in many states, spending is sort of out of control, and at some point, that is not going to be able to be continued, and so I think it's more likely than not that we are going to see increased taxes in the future to help cover these expenses and particularly to help shore up state budgets. So again, taxes are going to put pressure on your children, your grandchildren, and that is money that they are then not going to be able to contribute to their own retirement. So the fact of the matter is going forward, our children, our grandchildren are going to have a much greater challenge retiring. They're just simply not seeing the same generous employer contributions. Many employer plans are disappearing. We have college costs increasing far faster than the rate of inflation. Medical costs are going up far faster than the rate of inflation. Increased taxes, and then again, job losses and shocks to the economy, again, through no fault of our children and grandchildren. So again, it's just going forward, it's more likely that they're going to have a greater challenge retiring. And so to the extent that, IRAs, 401ks that may be converted to IRAs that they may inherit, that may be beneficial, very beneficial to them in helping to make up for those losses, help fund their own retirement. And so we want to make sure that to the extent we can, we are preserving and protecting that. So again, the two major objectives going forward, as it has been in the past, is tax reduction. So we want to look at both, the income taxes at both the federal and state level. And again, predator protection, from beneficiaries that, maybe are immature, have poor spending habits, maybe divorce, bankruptcy, creditors, lawsuits, loss of government benefits. Again, these issues, ever since passage of the U.S. Supreme Court decision in Clark v. Romaker, inherited IRAs, 401ks that may be, converted to IRAs, 401ks, those inherited qualified retirement accounts are no longer creditor protected. And again, I've had clients coming in and saying, well, hey, my children have good jobs, they're responsible, I trust them. And I say, well, if there's a divorce, they may lose that. If they have a medical issue that was unforeseen and have to file bankruptcy to get out from underneath that. Job loss, again, as we're recording this, there's over 30 million Americans right now that are unemployed through no fault of their own. So again, prior, I'd have clients say, hey, my kids have great jobs, they make more money than we do, I'm not worried about this. Well, maybe we need to, in light of current events, maybe we need to re-examine just how secure our children and grandchildren's jobs are going forward, and whether or not there may not be creditors around the corner or even a bankruptcy, or again, loss of government benefits. I do an immense amount of work for families that have special needs kids, Down syndrome, autism, Asperger's. The other thing is we are living longer and aging. An increasing number of people are ending up on disability in their later years. And what a lot of people don't realize is if somebody is receiving disability benefits and they inherit, the inheritance puts them over the income threshold and they can lose disability. In which case they then have to burn through their inheritance and then go back and try and reapply for disability benefits, which they may not get even though they had them in the past, and or the government can take that inheritance from them. Where again, if we have put it into the proper type of trust or vehicle, which we'll discuss, we can actually shield and protect those inherited assets from creditors, predators, and third parties. Again, whether that's poor spending habits, immaturity, a divorce, a bankruptcy, or even the government. So for most people, and again, this is up to $750,000 in IRA. So if you have up to $750,000 in an IRA or a 401k, after passage of the Secure Act, there's basically 3 planning options, okay? And we're going to walk through those. Again, naming individuals as beneficiaries. So if you're married, probably you're going to name a spouse as the primary beneficiary and then maybe the adult children as the contingent or secondary beneficiary. If you're single, it's maybe just naming the kids. So again, we have the option of just naming individuals as beneficiaries. That's one option. The second option is naming a trust as a beneficiary. And the third option we're going to discuss is converting some or all of your individual IRA to a Roth. And we're going to walk through sort of the pros and cons of each of those three options first. And then for those of you who may have IRAs over $750,000, there's also some additional advanced strategies that may apply, and we'll be talking about those. So first, we're going to discuss naming individuals as the beneficiary on an IRA. So again, we've already touched on this. Prior to passage of the Secure Act, they could take required minimum distributions out over their lifetimes. Now, after passage of the Secure Act, they have to take it all out within 10 years. And based on, where you kind of pass away at the time of the year of your passing, that stretch out may reach almost 11 years. So it's a 10-year rule, but depending on where you pass. So if you were to pass away, say here in 2020, as we're putting this together, they'd have some period of time between now and the end of the year plus 10 years. If you were to pass in 2021, depending on the time of the year you passed in that year, some period of time plus the 10 years. And they do not have to take any of that IRA out until the end of that 10 plus year period. So they could elect to take it all out in year 1. They could elect to take it all out in year 3. They could elect to take it all out in year 10, or they could take some out, say year 1, year 2, year 3, year 4, and then take the balance out in year 10. So how they take it out during that 10-year period of time is up to them. The rules just say that at the end of that 10-year period, they have to have taken it all out. But they may have to pay tax in a high bracket, and as a result may not achieve the maximum tax reduction. So just for example, let's say they allowed it to remain invested, compounding tax-free growth over that 10-year period, and then elect to take it all out in year 10. Well, as you can imagine, if they were to take a $200,000 IRA out all in 1 year, there would be a significant tax on that, plus it could put them into a higher tax bracket for income taxes. So now not only are they paying higher taxes on the income they earned that year, they're now also taking all of that IRA out in 1 year and paying the taxes on that. Versus say maybe they take it some out in year 1, some in year 3, the balance in year 10. But as you can see, when they take it out, they may have to pay taxes in a much higher bracket. Plus that individual receiving the IRA, again, has little or no creditor protection. Again, we've already talked about Clark v. Romaker, 2014, the U.S. Supreme Court said inherited IRAs are no longer creditor protected, and that continues. So not only do we no longer have the lifetime stretch out of the IRAs, and instead they have to take it all out somewhere in that 10-year period of time, but it is also still not creditor protected. So again, if they get divorced during that period of time, a spouse can take it. If they get sued, that creditor may be able to take it. If they have a medical emergency and have to file bankruptcy, if there's been a job loss and they have to file bankruptcy, those inherited IRAs are not creditor protected. If they were to go on disability, the government can take it. So again, not only do we no longer have lifetime stretch out, have to take it all out within 10 years, we also still do not have creditor protection. So what we tell clients are telling all of our clients is it probably only makes sense to name individuals as the beneficiaries, okay? When the total of your IRAs is currently less than 200,000, and or there's so many beneficiaries that each beneficiary's share is less than 150,000, and you don't have concerns about creditors or bankruptcy, divorce, okay? So if you have, total of your IRAs is less than 200,000, and you have adult children, and you don't have any concerns at all, okay, about them getting divorced, getting sued, having to file bankruptcy, or becoming disabled, then you may just want to list your adult children as the beneficiaries and let them decide how and when to withdraw the required minimum distributions over that 10-year period of time. But again, the big caveat, these are not creditor protected. And so again, if there is a divorce, if there's poor money management skills, there's a medical emergency, and then maybe they have to file bankruptcy. Maybe there's a job loss and they have to file bankruptcy. Maybe illness or some sort of disability where they have to go on disability or other forms of government benefits. Those inherited IRAs are not going to be protected. So kind of the rule of thumb is you name individual beneficiaries if you have less than $200,000 and you do not want to put creditor protection on that IRA for your children, grandchildren. Now, if you do have creditor concerns and would like to protect it, and or you have more than 200,000, may still want to consider doing a retirement protection trust. It's probably a better choice if you want to make sure that there is creditor protection for your kids and or you have more than 200,000. So now we're going to look at naming a retirement protection trust as the beneficiary. So again, we've touched on this. If you already have or set up a revocable living trust and you name that trust as the beneficiary, depending on how that trust was set up, it may have some or no creditor protection. However, because of the language we have to have in the typical standalone, your revocable living trust, very likely that within either 1 year or 5 years of date of death, your beneficiaries are going to have to take all of those accounts out. They're going to have to withdraw the balance and pay the taxes on it. So we're not even going to get the full 10-year payout. So instead, that's why we like to suggest using a retirement protection trust. And again, we've been using these for a number of years. Not a new concept. If you're watching this, you may have worked with us in the past to already set up a retirement protection trust. And that trust was designed to give the lifetime stretch as well as creditor protection. Now, as you're going to see in a moment, if you have an existing retirement protection trust, we're likely going to need to amend it due to changes in the Secure Act. But if you don't have one, and this is something you want to get, we can certainly help with it. But a retirement protection trust, again, is designed to provide creditor and predator protection on inherited retirement accounts while giving us the maximum stretch we can get on the Secure Act. And you are going to see coming up, and we're going to show you this in just a bit and discuss it, we can also do some things in there that we can get perhaps a longer than 10-year stretch out and or structure it in such a way that the taxes are being paid by beneficiaries in lower tax brackets. So again, the Retirement Protection Trust may achieve both tax reduction for your beneficiaries and predator and creditor protection. So we're going to show you now how that would work. So again, for beneficiaries subject to the new 10-year rule, and that would include your adult children, we would set up the Retirement Protection Trust, or we'd amend your existing trust to put in there what are called spray provisions. And these are designed to allow distributions to beneficiaries in lower tax brackets, say maybe a grandchild, while also permitting creditor and predator protection when appropriate. So we're going to show you now how that would work. Now, we should also mention quickly before we get there, now for beneficiaries that are still eligible for the stretch out, again, this would be a spouse or someone not more than 10 years younger, we may still name them as an individual beneficiary, but again, if control or protection is an issue, then we want to consider a retirement protection trust, again, where we may give up some of that stretch but we're still putting creditor protection on it. And for so-called eligible beneficiaries, again, this would be somebody who's maybe disabled or chronically ill, we're going to utilize the new eligible beneficiary provisions under the Secure Act to stretch the RMDs out for as long as possible, stretch out and defer those taxes, again, while also affording creditor protection. So again, this is how the new retirement protection trust would look. So assume for a moment we have 3 possible beneficiaries under the trust. So the first 2 are maybe adult children. So we have 2 adult children. Maybe one is a physician. The other one maybe, I'm just making these up for illustration purposes. Maybe the other one is a CPA. And then maybe we have a third beneficiary. Somebody that might be disabled, ill, not more than 10 years younger, but they're somebody that meets the eligible beneficiary rules under the Secure Act. So for the 2 adult children, we're going to make them the trustee of their individual trust that it would be created under your retirement protection trust. They have the 10-year rule. So at some point during the 10 years, and they can decide, they will have to withdraw the full amount of the inherited IRA. For the eligible beneficiary, we are going to put a third party in charge of that trust, and they still get lifetime stretch out under the eligible beneficiary rules. Okay. Now, as you set this up, you might be asking, well, how do I know which trust provision is going to apply to each beneficiary? Well, truthfully, we may not know until you pass away. So that's why we design these trusts to have what we call flex powers, okay? So that the trust is allowed to sort of change and morph the provisions that are affect that particular beneficiary once we know when you've passed away and who those beneficiaries are. And if you have an existing retirement protection trust, we may want to amend it now so that it is compliant with the Secure Act, and we're maybe removing some of the provisions that we had to have in there in the past that may not be the most tax efficient moving forward, and put in the so-called spray provisions and amend it to have these flex powers. So if you have an existing retirement protection trust, we're probably going to want to amend it now due to the Secure Act. Alternatively, you could change your beneficiary forms and just list your children as the secondary or contingent beneficiaries on it. So again, understand that if you name your children, it's up to them how they withdraw those IRAs over that 10-year period, and it is not creditor protected. If you want it to be creditor protected, to continue to be creditor protected in the way it was when we set it up under your existing retirement protection trust, then we're probably going to want to amend it. And then again, we can put in these new flex powers and spray provisions that would allow your adult children to sort of change how those taxes are paid to maybe beneficiaries in lower tax. So whether you choose option 1, which is just listing beneficiaries, if you have an existing retirement protection trust and you maybe just want to change the beneficiaries from your trust to your individuals, or you want to set up a retirement protection trust or amend your existing retirement protection trust, probably going to have to update your existing beneficiary forms. So again, the first 2 options we've discussed is naming beneficiaries or your individuals as the beneficiaries, or naming a retirement protection trust as the beneficiary may need to update your beneficiary forms. And again, if you have an existing retirement protection trust and you want to continue to use that, we're probably going to need to amend that due to the changes in the Secure Act, where we can put in these spray provisions and these flex powers to minimize taxes on it. So again, we've walked through the lifetime planning options of naming individuals and naming a trust. Now the last lifetime planning option we want to discuss with you is the option of converting to a Roth IRA. And the first point we want to make with this can be done in conjunction with the prior two options we've discussed. So the benefits of naming or of doing a Roth conversion is no more required minimum distributions for you and your spouse. Again, with a traditional IRA or a 401k that's converted to an IRA, that was pre-tax money. So you put it in pre-tax, it's growing tax deferred. And the whole point of the required minimum distributions is that the IRS wants you to begin withdrawing those funds to pay the taxes on it. Well, if you do a Roth conversion, once you convert it from a traditional IRA to a Roth, you are paying taxes on it, and as a result, you no longer have required minimum distributions going forward, and the growth can grow tax-free. So the withdrawals you and your spouse take later in life will be tax-free, and your beneficiaries may be able to take those withdrawals tax-free. Now there's some downsides to doing a Roth conversion. Okay, you have to convert the traditional IRA to a Roth. Okay, prior to your needing to take the RMD. So it's best to do that before reaching age 72. So now I want to pause and circle back to another change that was done with the Secure Act. So prior to passage of the Secure Act, under the old rules, you could start taking distributions at 59 and a half without penalty. You had to start taking distributions, thus your required minimum distributions, at 70 and a half. One of the advantages to the Secure Act is that they have raised the age at which you have to start taking RMDs from 70 and a half to 72. So that means you get a year and a half more of tax deferred growth before you have to start withdrawing the funds and paying the tax on it. And that was in part realizing that we are living longer. So that was one advantage of the Secure Act, is you no longer have to take RMD starting at age 70 and a half. They have raised that to age 72. Now that being said, if you do elect to do a Roth conversion on either a portion or all of your traditional IRA, you're probably going to want to do that prior to age 72 when you have to start taking the RMDs. Again, you're going to have to pay taxes at the point you do the conversion, but again, work with your financial planner, your accountant. There's some additional tax planning that can be done to minimize that tax, and that's beyond the scope of this discussion. Most of your beneficiaries are still going to have to withdraw under the 10-year rule. Okay, so if they inherit a Roth IRA, unless they're in what we call an eligible beneficiary, they're still going to have to withdraw it under the 10-year rule. But again, we can couple that with a standalone retirement protection trust to put creditor and predator protection on that inherited Roth IRA. So again, the rule of thumb is if you're considering converting to a Roth, you're going to want to have a professional run the numbers. Again, we would suggest sitting down with your financial advisor and your accountant and running the numbers to see if it makes sense to convert a portion or all of your existing traditional IRA or a 401k into a Roth. And if you don't do a Roth conversion, another option to consider is what's called qualified charitable distributions. Again, where you're taking your existing traditional IRA and making distributions of all or a portion of it to charities and using the charitable deduction. Another option would be to consider using withdrawals to fund 529 plans. So one of the things you could do is take the withdrawals and fund a 529 plan for a grandchild. Again, one of the things we talked about is the increasing costs of college, and how that is those costs are increasing far faster than the rate of inflation. It's making it harder for your children to fund their retirement as they're looking forward to having to pay for college costs for their own children, your grandchildren. And so perhaps using a portion of your accounts to fund a 529 plan for a grandchild. So that's another thing to consider. So again, the three options for IRAs under, say, 750,000. Naming individuals as beneficiaries. Understand they're going to have to withdraw within 10 years, and it is not creditor protection. They're not creditor protected. Setting up a retirement protection trust. Again, they're still going to have to take it out unless they're an eligible beneficiary. Still going to have to take it out within 10 years, but that trust now has creditor and predator protection on that inherited IRA. And we can structure it with flex powers and spray provisions to help minimize the taxes on that, or to consider doing a Roth conversion. And again, you can combine those three strategies. So for example, you could set up a retirement protection trust and maybe do a Roth conversion on all or a portion of your traditional IRA, and then name your retirement protection trust as the beneficiary on that Roth. Now, your beneficiaries are minimizing taxes that they may have to pay when they inherit that Roth, and that trust is putting predator protection on that inherited Roth. So three lifetime planning options for IRAs that are under 750,000. And again, you can mix and match. It's not like if you do one, you cannot do the other. So you can use all three. So with that, now we're going to move over and start talking about some planning strategies for larger IRAs. These would be IRAs, say, over $750,000. Again, now each of these is a bit more complex than what we've talked about. There's pros and cons to consider with each. And again, these are not things that we could sort of fully discuss here. If you have questions on these or want to look at them, certainly give us a call and we can schedule a meeting to walk through this planning with you and how these options might be utilized. So the first is to discuss what's referred to as a NING trust. And NING, again, is an acronym. It stands for Nevada Incomplete Gift Non-Grantor Trust. And I realize that is a mouthful, but it was initially set up in Nevada, and thus the term a Nevada Incomplete Gift Non-Grantor Trust. But this could also be set up in other states that do not have a state income tax. So for example, Florida. So as some of you may know, I am licensed in Florida as well as Minnesota. So this would be a planning technique and strategy for my Florida clients, and we can certainly use it for those of you that are in Minnesota. But basically, we are setting up a type of irrevocable trust that is set up in a state that does not have a state income tax, such as Nevada, where the name came from, or Florida, and there are others. But it's setting this trust up. Again, it's a type of irrevocable trust in a state that does not have a state income tax, and we are moving some or all of your qualified retirement accounts into that trust. And again, it's done in a way that minimizes taxes that may be due on that. And we can also design it in such a way that there is creditor and predator protection for the beneficiaries of that trust. Another option is a CRT, or a charitable remainder trust. And for those of you that are maybe not as familiar with a charitable remainder trust, you're basically taking an appreciated asset such as a retirement account. You're making the trust the owner or the beneficiary, and the trust is set up so that you receive the income from the trust. You could have your beneficiaries receive income from that trust upon passing. for a period of years. And then at some point, the balance of that trust goes to a charitable organization or organizations. And because the balance goes to the charity, you're getting a charitable deduction. And because it's outside of your estate when you pass away, it is escaping estate tax. So again, this is a way of minimizing taxes, state and other taxes that may be due on those assets that are in the charitable remainder trust. So again, a charitable remainder trust is a vehicle for minimizing taxes. The other thing we might want to consider is an IRA replacement through the use of IRA withdrawals to purchase life insurance. So for example, you reach 72, you start taking the required minimum distributions from your IRA, and you pay the tax on it, and then perhaps we go and get a life insurance policy. We use the distributions from your IRA to make the premium payments on that policy, and then we set up what's called an ILIT, an irrevocable life insurance trust, and we have that ILIT hold that life insurance policy. Then upon your passing, maybe a spouse and or children, grandchildren are the beneficiaries of that policy. Because it's an irrevocable trust, it is outside of your estate for estate tax purposes upon your passing. The beneficiaries of that trust receive it tax-free because it's a life insurance policy. They do not have to pay income on that inheritance. They don't have to pay estate tax on it. When they inherit it. And we can also design that trust so that, again, the policy proceeds are creditor and predator protected. So again, we could take the RMDs from that IRA, use it to fund a life insurance policy that is outside of your estate for tax purposes, and leverage that into funds that are then protected for your children and grandchildren. So that would be another option to consider. There are also additional planning options when IRAs are inherited. So again, we've talked about if you name your adult children as the beneficiaries. They could disclaim, they could say, hey, I don't want this, and then it could cascade down to others in perhaps lower tax brackets. They could use deductions or other planning options themselves to perhaps offset the taxes due on withdrawals. They could convert inherited company plans to Roths. So if you have a traditional IRA, they inherit it, they could then convert that to a Roth. So these are all options, but again, these really aren't substitutes for good lifetime planning by the IRA owner while they are alive. So where are we now? We've given you an overview of the Secure Act and some of the potential planning options, okay? And what I want you to realize is your planning has to be customized to you and your beneficiaries. There simply is no one-size-fits-all planning, and that was the case even before passage of the Secure Act. As I was sitting down with my clients and sitting down with those of you that are clients, as you'll recall, you probably recall me walking through with you and saying, here's the options, here's the pros and cons of those options. Based on what you're telling me you want to achieve and accomplish and what you're telling me about your family, here would be my suggestions. And that is certainly that continues to be the case, and that's the case moving forward. Again, there is no one size fits all. However, I want you to realize that with passage of the Secure Act, it has fundamentally changed how we plan for qualified retirement accounts. We've gone from lifetime stretch on inherited retirement accounts to a 10-year rule. Prior to passages of the Secure Act, inherited IRAs were not creditor or predator protected after the Clark v. Romaker decision in 2014. That continues to be the case. And so prior to passage of the Secure Act, we were looking to get the maximum stretch we could, minimize taxes, tax-deferred growth, while putting creditor and predator protection on it. Now we have a situation where all but for eligible beneficiaries, Uh, we likely have a 10-year time frame, still no creditor predator protection. And so how we are approaching our planning is different now, so that we are trying to minimize the taxes to the fullest extent we can within that 10-year window, while continuing to put creditor protection on it. And again, we've touched on 3 planning options for IRAs under 750,000. Again, you can combine those options, naming beneficiaries, naming a retirement protection trust, doing a Roth conversion, and again, you can combine all or some of those. And then we've looked at some potential options for IRAs above 750,000. We've looked at named trusts. We've looked at doing charitable remainder trusts, and then potentially using some of the IRA, the withdrawals, to replace retirement accounts with life insurance that may go into an ILET. So those are some of the options we've covered. So what's your next step? If you have an existing retirement protection trust, give us a call and we can schedule a review meeting. As if you want to continue to use a retirement protection trust to provide creditor protection for your beneficiaries, we're likely going to need to amend that trust due to the Secure Act. We're likely going to need to amend it and put in the flex powers in the spray provisions that we discussed. Again, prior to passage of the Secure Act, we had what we called conduit provisions. We were trying to get the maximum stretch we could. Now that we're dealing with a 10-year window, we're going to want to amend that and put in spray provisions and flex powers while still maintaining creditor protection. So if you have an existing retirement protection trust and you want to continue to provide creditor protection, we're going to want to amend that. If you aren't as concerned now with creditor protection for your beneficiaries, then maybe rather than having your existing retirement protection trust as the beneficiary, you're just going to switch your beneficiary designations and name the adult children. Understanding that we're not as concerned now with the stretch. If you named them the beneficiaries prior, they could take it all out whenever they wanted, and they blew the stretch. And so we were putting it into that trust to sort of force that stretch. Well, now with a 10-year window, maybe we're not as concerned about that. So if you're not concerned about creditor protection, you have an existing trust, you could just name your adult children. They can take it out, withdraw those funds within the 10 years however they see fit. But again, be aware, big caution, it is still not creditor protected. So if you want the creditor protection, you have an existing retirement protection trust, we're probably going to want to amend that trust. If you don't have a retirement protection trust in place, but you want to help your heirs pay lower taxes while protecting the retirement accounts they inherit from you, then you may want to consider getting a retirement protection trust in place, in which case give us a call, send us an email, we can get you on the calendar, and we can talk about how we can put a trust in place that provides creditor protection for your heirs, your children, grandchildren, and how we can structure that again with the spray provisions, the flex powers to minimize the taxes on it. If you have a beneficiary that would qualify as an eligible beneficiary, we can still get the stretch out on those retirement accounts. And if you have retirement accounts that are worth more than, say, $750,000, then we can discuss some of the advanced planning options we covered here today, such as the Charitable Remainder Trust, the Nevada Incomplete Gift Non-Grantor Trust, or the use of an ILET. So quick recap of what we covered. So prior to passage of the Secure Act, the government made a pact, and it told all of us that you could put money away for your retirement, and it was going to grow tax deferred. And then when you reached an age, you could start withdrawing that, 70 and a half. And then when you passed, you could pass the balance of that to your kids. And they could use that inherited retirement account to help fund their own retirement while it continued to grow tax deferred. And so that's what you did. Well, in effect, what the government has said with the Secure Act is, well, we know we told you that, but we now want the revenue, so we're changing the rules. And that's in effect what they did. This is one of the largest tax increases we've seen. And as we pointed out earlier, somewhere between 45 to 55% of your IRA, your qualified retirement account under the 10-year rule is now going to sort of disappear. It's going to be taxed. Whereas in the past, child could inherit, allowed to grow tax deferred, grow to 4 to 5 times the value of that account, help them to fund their retirement. So again, that's what you did. And now with the Secure Act, the government has basically said, yeah, even though that's what we, told you could do, and this is the deal we made, we now want the revenue, and so we're changing the rules. In effect, now we can help you preserve and pass along as much as possible under the new rules. So again, the government made a pact. Put your money away for retirement and allow it to grow tax deferred. Now you could pass the balance to your kids and they could use it to help fund their retirement while continuing to grow tax deferred. So you did it. The government now wants the revenue, so they've changed the rules, but we can still help you preserve and pass along as much as possible under the new rules. So if you'd like to look into amending your existing retirement protection trust, or if you don't have one but would like to get one in place, or you want to discuss some of the other advanced planning options I covered, give us a call. You can email us at info@roulettelaw.com or give us a call at 763-420-5087, and we can schedule a time to look at your existing trust, discuss amending it, discuss getting a new trust, a new retirement protection trust in place for you and your family, or to discuss some of the other planning options we've discussed if you've got retirement accounts worth more than $750,000. So again, I hope you found this overview of the Secure Act helpful. And again, if you have questions or would like to look at amending or updating or getting some additional planning in place, email or give us a call.